Hey, good morning, everyone. Welcome to the Access Quarterly Training. It's good to have you guys here. Like I just mentioned, I think this is the largest training we've ever had. So if you are a returning part of our Access community, you've been at these before, welcome. It's good to see a lot of familiar names and faces. And if it's your first time here, welcome. And we're really excited to have you joining this webinar with us today. The topic of today's webinar is Mental Health Law 101 with Erik Nickels. And I do just want to point out if there's anyone on this call that originally registered for this May 19th training about a month ago, at that point in time, the topic was beyond our belongings. The topic has since changed. Hopefully you received that notification. But if you were expecting that training, just know we will be trying to offer that again or offer it soon, reschedule it soon. So keep an eye out for that. But we think this new topic will be super valuable as well. So we're glad you're here. Grateful to have Erik with us. And yeah, we'll do some quick introductions. My name's Jocelyn Farrell. I'm the program coordinator for Access California, and we'll be facilitating today along with Nicole Chilton, our program manager. Presenting today is Erik Nickels. He's a senior attorney at Mental Health Advocacy Services in Los Angeles. Erik founded and helps lead MHAS's project serving transition age youth. And he also frequently advises consumers and their families on their rights in the behavioral health system and how to navigate inpatient treatment. So he brings a lot of expertise, and we're really grateful to have him with us today to share that expertise. A little bit about MHAS. Their mission is to protect and advance the legal rights of low-income adults and children with mental health disabilities and empower them to assert those rights in order to maximize their autonomy, achieve equity, and secure the resources they need to thrive. A little bit of housekeeping. The training is scheduled for 2 hours. The training is being recorded, and it will be made public on our YouTube channel. It'll be posted within a week or two. If you would like to speak, you may raise your hand, and then at an appropriate time, when Erik stops for questions, we will unmute you. If you would like to add questions to the chat box, you're welcome to do that at any time. We will read the questions aloud so that they will be included on the recording as well. And then we're going to launch a demographic poll in a moment, and that's just to gather information on where you guys are coming from, agencies and counties and things like that. So if you could fill that out, that would be great. Couple quick ground rules. We just ask that you honor yourself and practice self-care throughout the meeting. Feel free to get up, and if you need to get a drink of water or something, you're welcome to do that. Model the behaviors you want to see in others and honor the other attendees on this call. Assume good intent in one another, and even if you disagree on things, focus on the issues and the facts at hand, not on individuals. Look for areas where we align with one another, and if we do disagree, disagree respectfully. Try to remain solution-oriented, and then out of respect for everyone on the call, because it is a very large training today, please keep your questions and comments brief when you come off the mic. If there's other ground rules you would like to include, feel free to put those in the chat at this time. And now I'm going to hand it over to Erik and launch the poll. So thank you again, Erik, for being here today.
Thank you, Jocelyn, and thank you all for joining us this morning. It's a real pleasure to be here with you. I am looking forward to a really engaging conversation about mental health law. Again, I want to just say I really appreciate you all joining. I know A, we're always busy, and B, with the May budget revise coming from the governor's office, a lot of us are fighting unexpected cuts that we weren't prepared for. So I know it's a busy time. I really appreciate you all joining, and I hope I can make it worth your while. I'm going to now share my screen and launch into some slides I prepared. All right, here we go. So again, the topic today is Mental Health Law 101. I'm going to give you kind of the attorney's perspective on the issues that you're all dealing with every day in the behavioral health system, the mental health system. Jocelyn already gave our little overview. Just to sort of flesh this out a little bit, So you understand like our role in this process. We're a civil legal aid provider in LA County, so we're providing a mix of civil legal services to low-income folks with mental health disabilities. I noticed there was already a question, are we the PRA for LA County? The answer is no. What we are doing at MHAS is mostly work with folks who are consumers of the public mental health system, but we're doing work outside of the main mental health system. So we're helping them with housing. We're helping them with SSI appeals. We're helping them with a consumer finance issue. We're doing the sort of ancillary civil legal things that keep people in the community stably housed on a stable income and that allow them to thrive and to live in the community and not in an inpatient setting. As you can see, we've been around since 1977. In a few slides, I'll give you a brief overview of where we come from, like how we got started, because that actually ties into all of this. We're in LA County, physical office in Glendale, and we do a mix of a lot of different stuff. So here's the roadmap. They teach you in law school to give a roadmap before you start a presentation like this. So I want to sort of give you the overview of what we're going to talk about today. I think my main goal today is to put mental health law and the moment we find ourselves in the mental health system in historical context. Because spoiler alert, things are very in flux right now. Things are really changing. There's a great debate ranging about what mental health law should do and where we go from here. We have been here before. This is not the first time we've had this great debate. This will not be the last time. So I want to talk about the historical context of the history of mental health law, the past great debates we've had, how we got to where we are today, and where we might be going from here. I also wanted to to lay out this sort of broad theme. Again, from the lawyer's perspective, what mental health law is trying to do is balance these two really fundamental interests. It's trying to balance individual autonomy, the rights of the person in the mental health system when they're in the hospital or conserved or going through court. It's trying to balance those individual civil rights interests with public safety, right? The state's duty to protect people, whether they be a danger to themselves, a danger to others, gravely disabled. That's a compelling interest the state is trying to meet. And mental health law is where those two things intersect. It's trying to find the right balance between individual rights and individual autonomy and quote unquote public safety. And that is one reason these debates are so fever pitched, because these are two very compelling interests. People feel very strongly which one should outweigh the other at any given time. And that's why the stakes here are so high, because this is really a fundamental legal debate. Which of these two things should win out at what time says a lot about a society. And then the other theme, again, I've already hinted at this, but we've repeatedly in the history of mental health law in this country, we've hit these times of crisis where we realize the system isn't working, and we've hit an inflection point as a result, and we've kind of blown it all up and tried something else. Again, my thesis is that we are in another one of those moments right now, but we'll talk about that. I just wanted to put that theme out there that we've kind of been here before. We hit these breaking points and we change everything at these major inflection points. So let's go back to the beginning. Let's go back to 1787 when the Constitution was created and the United States became the legal system we have today, more or less. I think it's worth remembering that mental health and mental health law weren't a thing then, right? We didn't have a concept of mental health. If somebody had symptoms of a mental health condition, they were just incarcerated. They were considered to be unruly and a disruption to the public good, and we just sort of locked them up and moved on. Best case scenario, you get out when you start to feel better. Worst case scenario, you're there for a very long time. So mental health and mental health law did not exist at the founding of this country. It's one reason I, as an attorney, get frustrated when I hear other attorneys talk about originalism and we have to always use the historical context of the Constitution. Well, things have changed pretty dramatically since then, right? We didn't know mental health was a separate concept that could be treated and improved with the right options. At the time, there was no balance between individual autonomy and public safety. It was all public safety, although it wasn't really safe either. I would argue it's not safe to just round up people who have symptoms of a mental health condition and incarcerate them until they seem better. So we were totally getting this balance wrong at the founding of this country. And there wasn't a lot of mental health treatment, and there certainly wasn't any mental health law like we're going to talk about today. So I think it's obvious that this was a really bad system. And one of the ways we realized it was a bad system is that our concept of mental health grew. We began to realize that these are conditions. They are the product of a lot of different factors in people's lives. They can be treated with the right treatment options. And it's not the best system to go all in on quote unquote public safety and just lock people up. We need a more treatment-based, more empathic, more humane model. And so slowly we reached a point where we were no longer happy with the system we had, and we hit our first crisis. We hit our first inflection point. And at that inflection point, the big solution was, okay, let's do something more treatment-based. Let's try not to just lock people up. Let's build asylums. Asylums will be these specialized inpatient mental health care facilities, and we'll send people there to get better. The problem is these asylums functioned roughly like jails. There wasn't a lot of treatment going on. Again, our concept of mental health was very, very nascent. We didn't really know much about it yet. So what treatment was being provided wasn't very high quality. The conditions in asylums were very brutal. So again, that individual autonomy piece was being really kicked to the curb in favor of public safety and forcing people off the street and into a locked facility. So we realized that didn't work either. And the picture here is of Nellie Bly. You may have heard of her. She's this sort of very interesting figure from American history. She fits into the history of mental health law because she was a muckraker. She was one of these journalists that would sort of write these very detailed exposés about some sort of societal ill. And she would go into asylums in disguise as somebody who was inpatient and would experience what was happening in these asylums and then would come out of the asylum and report back. And her reports were that the conditions were brutal, that these were people who were in need of care, in need of treatment, in need of a calm environment at the very least. And they were in a really, really difficult environment where they weren't being treated, where they were being pretty seriously abused and neglected most of the time. And she made the case that this is not what we want for our society. This is no different than what we had in the beginning with just jailing people, and this isn't working. And a lot of people in the progressive movement like her led us to our next inflection point. We realized this system of asylums was not working. It was also extremely expensive. These are hard to maintain, hard to build. So at our next inflection point, we again said, let's do a more treatment-based model. So asylums gave way to hospitals. And again, the theory of a hospital was going to be that it was calmer, more care-oriented. Our concept of mental health had greatly improved by this point, so there were psychiatrists and there were some talk therapists. There was actual mental health care that could be provided in these hospitals. So the theory was let's get people into a better, more treatment-centered environment and let's actually try to take care of them. Well, that didn't work either. We hit another breaking point many years later. By 1955, 500,000 Americans, 500,000 of us, lived in a psychiatric hospital. And I use that word, lived, very deliberately because the system we had very little checks on it, very few checks on it. So if you were judged to be suffering from a mental health condition and you were sent to the hospital, there weren't a lot of checks on, well, should you still be there months later? So there were a lot of people who were sent to these hospitals who never got out, who were just stuck there in perpetuity. And again, I use that word deliberately lived because a lot of people were there full time, or at the very least, repeatedly cycled in and out and didn't have much stability in the community outside of hospitals. These facilities were not that different from asylums. They were overcrowded, they were understaffed, they were very violent places, sometimes violence from the staff, sometimes violence between patients. They were not good environments. They weren't a significant improvement on asylums. And again, confinement was indefinite. You didn't know how long you were going to be there. And it was arbitrary. You didn't have much of a chance to challenge it. You didn't have much of a chance to say, I don't need to be here. There weren't a lot of clear rules for who needed to be there and who didn't. So there were a lot of people who were just stuck there. And that is where my organization came to be. The history of mental health advocacy services is that the group of lawyers that would become our organization banded together and went into hospitals in LA County and tried to A, raise awareness to what people were experiencing, and B, get people out using any legal tools they could think of. So they would file habeas corpus petitions arguing that people in these hospitals were illegally detained. They would make videos and spread these videos to policymakers and to the public. And in these videos, patients at the hospital would say, I've been here for years. I don't know when I'm getting out. I miss my life in the community. My first day as a summer law clerk way back in 2019 at MHAS, they showed me this video. And this video has always stuck with me because what I saw was a complete failure of the legal system. And I've always been motivated to keep us from going back to that point. Um, so I think it's fair to say that to this point, when you look at all the inflection points that had come until now, when you look at all the changes we had made, the entire history of mental health law in this country, it had failed us. From a legal perspective, an attorney would tell you that this was a constant violation of due process. Due process is very simply the ability to challenge one's confinement, to, have legal checks and legal protections on the process of taking away someone's rights and someone's liberty. This system had a lot of people simply warehoused in hospitals without any meaningful opportunity to challenge that. And so that's unconstitutional. That strikes at the very fabric of our legal system, and that is not a workable policy. And then from a policy perspective, we had many, many years of data to this point. We could start to say that, warehousing people in these locked facilities with no meaningful path to treatment or returning to the community where their friends and family and jobs are doesn't work. That doesn't make people better. It actually makes them worse, and it compounds the problem. We also, again, started to realize that generally speaking, coercive treatment doesn't work all that well either. So that led us to the next breaking point, the next inflection point, and that was deinstitutionalization. The theory behind this was, okay, we've tried a lot of really heavy-handed, coercive things like locked facilities, and it hasn't worked. So why don't we try to treat people in the community? Why don't we do things on a more outpatient basis? The idea was to fund these community-based mental health treatment centers. This would be a sort of one-stop shop where you go and you see a talk therapist, you see a psychiatrist, you get your medication. All of our mental health care will be handled through these outpatient community-based centers. We will have some inpatient beds, but that'll be reserved for people who are really in crisis, who are acutely in need of intensive care. That's not going to be the default anymore. The default before was beds in locked facilities. That's only going to be for people who are in immediate crisis. Most of our everyday mental health care will be done at these community centers. One thing that was underpinning this idea of deinstitutionalization is the rise of psychiatric medication. A lot of psychiatric drugs, particularly antipsychotics, hit the market for the first time around this time. And there was a lot of hope that this would be sort of a fix to the problem. Anybody who had serious mental health symptoms, if we just find them the right pill or the right combination of pills, there won't be any more mental health problem in our society. We'll just medicate our way out of it. And again, there will be this inpatient bed space, and the law will allow for involuntary commitments to those beds where necessary. But those stays are going to be, again, only for people who really, really need it. They're going to include a lot of due process protections. The goal is going to be to stabilize patients and get them back into the community. We're not going to keep them there for the long term. We're just going to stabilize them and get them out. I think it is worth pausing to acknowledge how many successes deinstitutionalization has had. This is a meaningfully different system from what we had before. When you look at the evolution from jails to asylums to hospitals, I'm not sure there was that much difference between any of those steps. This is meaningfully different. As an attorney for people with mental health disabilities, I can tell you it's my view that under this system, patients' autonomy and their due process protections and just their general civil rights, their individual autonomy greatly increased. For the first time in that sort of age-old struggle between individual autonomy and the state's interest in public safety, individual autonomy is actually being honored. It's actually a part of the equation for once. I also think we should acknowledge that the successes of deinstitutionalization contributed to broader disability advocacy. When other disability advocates saw that, hey, this community-based model really works, they pushed for it in their own ways. And it's my view that this ultimately culminated in the passage of the Americans with Disabilities Act, which is one of the finest civil rights statutes in the world. It's a really, really good law and has made a really significant impact in people's lives and continues to today. So deinstitutionalization, I think, sort of set the stage for the massive success of the ADA, which integrated people with disabilities into our community in a way they had never been before. And then again, as a lawyer, I would be remiss if I didn't mention my favorite Supreme Court case. In the late 90s, the Supreme Court decided Olmstead, LC versus Olmstead. LC was the plaintiff who you see here on your screen, Lois Curtis. Miss Curtis lived in Georgia and received Medi-Cal from the state of Georgia. Sorry, excuse me, Medicaid. She wasn't in California. She received Medicaid from Georgia. Medicaid required a lot of care to be provided in congregate locked inpatient facilities. Miss Curtis had an intellectual disability, and she argued that I shouldn't have to go into this restrictive locked facility to get my care funded by Medicaid. That's disability discrimination. And the Supreme Court agreed. The Supreme Court held that under the Americans with Disabilities Act, a failure to provide community-based services, a disproportionate routing of people into these inpatient locked facilities is disability discrimination, and that's illegal under the ADA. So this was a massive win for people with disabilities. Olmstead is still a good case. It is still a frequent guest in a lot of courtrooms and a lot of high impact litigation. You can use it to score some really big victories for people with disabilities, in particular people with mental health disabilities. So all of this is wonderful. And this is possible because of the movement that led us to deinstitutionalization. And we should call out these successes. But it wasn't perfect, right? There were some failures of this movement as well. For one thing, we never funded community-based mental health treatment. These centers that were supposed to be the hub of psychiatric care never really came to fruition. Part of that was due to federal cuts. Part of that was due to not being funded at the state level. But, long story short, the money wasn't there to make these things as accessible and as common as they needed to be. Also, we have learned the hard way that medication does not fix everything. Medication is a very important part of a lot of people's treatment regimen. But this idea that, well, we'll just get everybody the right cocktail of pills and that'll fix it, we know now that's absurd. Mental health is a complex result of sort of all the factors in your life. And you can't just medicate your way out of it. And part of our reliance on medication led to my next point, which is that we have taken too narrow a view of mental health in our society. We view it through the medical model of disability. We say that a mental health condition is a condition, and it's something that is wrong with the person who has it, and we should be able to treat it in the right way, whether that's medication or talk therapy or whatever it is. It's this discrete issue with this person. A lot of times the medical model says it's neurochemical, like if we just get the neurotransmitters straightened out, that'll fix it all. We've taken this medical model view of disability, and we have forgotten about all the things that contribute to one's mental health. So if you were really serious about improving mental health, you would fund supportive housing. You would fund supportive employment. You would fund community centers where people can spend time together and meet people and make friends. You would address all of the factors that go into one's mental health. You wouldn't just treat it as a condition. And I think this deinstitutionalization was always doomed to fall short of its goal if we took such a narrow view of mental health and how to treat it. The system we have now leaves us with inpatient treatment remaining very common, and I would argue very problematic. I think many of you know that the conditions in these hospitals are not always great. A lot of people have bad experiences in these hospitals. Um, I have spoken to a lot of clients who are very fearful of inpatient treatment because of bad experiences they've had in the past. So we haven't fixed the problems with inpatient treatment. And I would say that these failures, again, deinstitutionalization had a lot of successes, but these failures that it also had are catching up to us today. And they're contributing to our latest inflection point, which we'll talk about in a few slides. I do want to pause here. I see there's some comments. I can't really see them when I'm in screen share mode. So I want to pause. If anybody has any questions, if there are any questions in the chat that you'd like to read out to me, we can take just a second to do that.
I think the questions that everything in the chat so far, people are introducing themselves.
Okay.
But if there are questions that I'm missing in the chat, people can raise their hand. Oh, Shireen. Yeah, we have a hand raised from Shireen. I can't hear you, Shireen, if you're talking right now. We also have a question from Arandira, and we can come back to Shireen if your mic starts working.
Mhm. Good morning, everybody. Well, I guess my question is around knowing all of these things. If we were in that situation that we think that, like we're not getting um, the right treatment, how can we connect with someone, experts like you, Erik Nickels? Like, do we have to request it through the medical system? Like, for someone to help deal with the situation?
Mhm. Yeah, if I understand your question correctly, it's that, what happens when somebody's in inpatient treatment or in the mental health system and they're not getting the care they need?
Exactly.
Yeah, that's a big question, and that's kind of one of the problems with our current system. The short answer is you contact your local patients' rights advocate, your PRA. That's a different organization in different counties, but it's their job under the law to advocate for patients. That's the legal answer. There are also sort of practical things you can do. So if a consumer is actively not getting the care they need, I always advise people to just make a stink, right? Like if you're that person's family member, friend, provider, whoever you might be, show up at the hospital, make phone calls, make sure they understand that, this patient has a support system and that you're watching what happens. I think just being there and being visible to them is helpful. And then we're also going to talk about psychiatric advance directives in a couple slides, which is a way to plan ahead for being in inpatient treatment. And I think that's also an important piece of it.
Mhm. What do you say that the PRA means or stands for?
PRA is Patients' Rights Advocate.
Oh, patients, and everybody has that.
Hmm.
I'm guessing. Okay.
Yes, yes,
Thank you so much.
of course.
Okay.
Okay, I'm back.
Shireen,
Can
can we
you hear
try
me?
again? Yes, we can.
All right, great. I just wanted to see if you guys can put your website in the chat or the YouTube link where I can find you guys and find other resources.
You guys meaning us, MHAS? I'd be happy to do that
Yes,
at the end of
please.
the
I'm
presentation.
sorry.
Yeah, yeah.
Yes,
Just want to
thank
make
you.
sure you didn't mean access. Yeah, I will put our website in the chat.
All right, thank you.
And one more question from Pat.
Hi, forgive me if I'm catching up a bit. So whenever I see this Lanterman act,
Mhm.
um, I think, oh, this is the source of why the police have been involved in everything, um, until recently. Uh, so I want to get your response to that.
Yeah, we will talk about that. I have some things to say about that for sure. All right. I think that's a good point to thank you all for your questions. I think that's a good point to continue with the presentation. So that is a nice segue to LPS, the Lanterman-Petrus Short Act. As we were saying, we hit this point where we've decided to deinstitutionalize, we've decided to do community-based treatment. This is the law that California enacted to bring that about. So just as a very brief, like zoom out legal overview. So, of course, there are federal laws that affect mental health policy, but generally, when we're talking about mental health law, we're always looking at a state law. The reason for that is that the mental health policy is within a state's police powers, which is defined as the powers to regulate health, safety, welfare of citizens. The 10th Amendment reserves those powers to the states. So generally, when we're talking about mental health law, we're looking at state policies and state laws. Um, so let's jump into California's state law. I think I have a pretty knowledgeable crowd here. I think you all know what LPS is and the general sorts of things that are in it. The point I want to make on LPS is, again, look at its language, look at what it's trying to do. It's clearly a deinstitutionalization statute. It is coming down firmly on the side of individual autonomy. It's saying that we have for too long overemphasized public safety and de-emphasized the rights of actual people in this system. And this is a reaction to that, and this is an effort to change that. You can see in the preamble to the law, it says it seeks to end the inappropriate, indefinite, and involuntary commitment of persons with mental health disorders. That's what it's trying to do. And also, I know things are changing really dramatically right now, but we are still mostly operating within this framework. The Lanterman-Petrus Short Act is still our mental health law. It still has the rules that govern the mental health system mostly. So this is still, and this is, I think, good news. This deinstitutionalization statute is still good law. It's still the law which we're mostly operating under. I mentioned it weighs heavily in favor of individual autonomy, but there's two ways in which public safety can win out. It permits involuntary holds and it permits conservatorships. Conservatorships are a bit outside of the scope of this presentation, although if there are questions, I can say something briefly and generally about them. Involuntary holds, again, I think I have a knowledgeable crowd here. I think you all mostly know how this system works. Long story short, if you are found to be a danger to yourself, a danger to others, or gravely disabled, you can be involuntarily held in a hospital against your will for up to 72 hours. I will say that you see on this chart, there's all these different steps, there's all these hearings, there's all these rules for how long you can be held. This is a very different system than what we had before. There are really significant due process checks built into this. But at the very beginning, this is a remnant of the old system. This initial hold, the so-called 5150, you don't really get any due process whatsoever at this stage. All there is a certification that the hospital staff signs. And if they say you are one of those three things, then boom, you're 5150'd. That is a remnant of the old way in which people would simply be locked up without a lot of control. I have a colleague from law school who is a public defender, and she always says that this 5150 is incarceration without due process. So although we've built a much better, much more orderly, much more due process forward system, this is a remnant of the old way. And as an attorney, my critique would be there ought to be more due process at this first stage. After that first stage, of course, most holds end, but some are extended to that 5250, which is up to 2 more weeks. You do get some sort of due process check at that stage. You're entitled to some sort of certification hearing. Then the process changes based on why you're in the hospital. If you're a danger to self, it's one more 14-day hold, and then that's it, unless you agree to switch to voluntary treatment. If you're a danger to others, you're not so lucky. There are renewable holds of up to 6 months. They can basically keep you until they think you're no longer dangerous. This is one way that public safety wins out over individual autonomy. And then, of course, there's gravely disabled. Gravely disabled just means unable to meet one's own basic needs for food, shelter, medical care, that sort of thing. For a grave disability, there's a final 30-day hold. If you make it through the end of that hold, then you are eligible for a conservatorship. And I will say, I imagine there probably will be some questions about conservatorship, so I'll just say a brief piece about them. I have a lot of family members who call me for advice on how to conserve someone, and they're very frustrated to learn that they have very little control over the process. This is a common critique of mental health law in California. The conservatorship process can only start after somebody's been through all of those holds for grave disability. And then the hospital, at least in LA County, the hospital has to make a referral to the public guardian. Then the public guardian has to investigate, and they can either not go forward or file a petition with the court. And then the court has to hear the case and decide. So there are a lot of steps in this process. Again, this is one way we're trying to value individual autonomy. We're trying to put a lot of checks on this because a conservatorship is a big deal. A lot of family members express a lot of frustration with how little control they have over that process. They can't initiate it. They can't make the public guardian, make the referral to the court. And that's by design. The system is set up that way for a reason, to protect the individual autonomy of people who go through it. Now, let's turn to the last question I got from Pat, and talk generally about the reality of inpatient treatment. Again, I think this is not news to most of you, but most hospitalizations in our current system are initiated by force. They are done by the police. What the Lanham-Petras Short Act says is that the involuntary holds can be initiated by medical staff or by law enforcement. And in practice, they are mostly initiated by law enforcement. I've had many clients who, the police respond to some sort of call, some sort of situation, and they handcuff the person, they put them in the back of a police car, they transport them to the hospital. They might even offer them the choice. They say, we'll either take you to jail and book you on these charges, or we'll take you to the hospital and 5150 you. I mean, I think the hospital is the choice that most people are going to make in that situation, but it's not really that different from jail in a way, because you're being taken to a locked facility against your will with no immediate ability to challenge it. So most hospitalizations are done by the police, which can be very traumatic even when handled well. When you get there, the environment's pretty tough. These don't look that different from the old system of state hospitals. They are underfunded and understaffed. I think the staff are doing the best they can, but they don't have the resources to treat as many people as they need to. So a lot of times, and again, the law says that you can kind of do whatever you need to do to stabilize patients. And so a lot of times what hospital staff decides to do is to do that as quickly as possible. So hospital stays often include seclusion, restraint, forcible medication, interventions that may be necessary in some cases, but I think they're used pretty frequently. And I think even if they're used correctly, they're really, really traumatic for the consumer to go through. I mean, this is really difficult stuff. This is what happens in hospitals. My clients tell me that the hospitals they've been in are violent, they're crowded, they're cold, they're dirty. They are not environments that are conducive to well-being. They're not environments that help you get stable and help you get back in the community. I always say that with a hospitalization, the so-called collateral consequences are very steep, meaning that the more time you spend in the hospital, the more stuff piles up outside of it. So you may be in the hospital at the first of the month and miss your rent payment, and now you're behind on rent and your housing's unstable. You may run out of sick days at work or not have easy access to a phone call to call out sick, so now your job is in jeopardy. You may have a pet or a plant or a family member that needs your care, and you're not there to care for them suddenly because you've been hospitalized. The longer you're in the hospital, the more stuff can go wrong. The more there can be these collateral consequences waiting for you when you do get out. And those collateral consequences put your housing at risk, they put your income at risk, which in turn can make you stressed and anxious and make your mental health worse, which in turn leads you to going right back to the hospital. This is how that cycle starts sometimes. So my bottom line of inpatient treatment, the way I see it as an attorney, is at its best, it's a very traumatic process. I don't think anybody would tell you that we need to do away with it completely. I know people whose lives have been saved by inpatient involuntary treatment. I don't think anyone would seriously say we've got to get rid of it, but I would make the case that at its best, when it's necessary, when it's working, it's extremely traumatic. And at its worst, it's just flat counterproductive. I have lost count of the number of people I've spoken to in this job who tell me I will never go back to a hospital because my experience was so bad. And I will never seek out the care of a therapist because I don't trust that that therapist won't send me back. And I'll never take medication because I don't trust the psychiatrist not to send me back. we are doing a lot of damage to people's mental health treatment regimens with these very scary, very traumatic inpatient treatment holds. So that's a big problem, and there's lots of work to do there. One way that we try to mitigate this as attorneys, and I know, again, there are a lot of you on the call who are familiar with this concept, the Psychiatric Advance Directive. When I started giving presentations like this 4 to 5 years ago, nobody, maybe one or two people on a call, but generally speaking, nobody had heard of these. And I had to sort of start from the beginning. And I think we've seen real growth in these over the last few years. I have spoken to a lot of you in other settings where you've told me about your pad work. I think it's wonderful that these are becoming more common. I want to do two things on pads. One, if you're new to them, I want to introduce you to them. I want to give you a flavor for what they are, how they came about, how you use them. And then I also want to talk about best practices. Let's say you know what a pad is, or you're interested in it after hearing this discussion. And you want to know, how do I help people get pads? How do I make a pad of my own? What's the legal landscape around pads? I want to do both of those things. So first, to start with the basics. A Psychiatric Advance Directive is a legally binding document that expresses your preferences for inpatient treatment. These are based on the regular old Advanced Healthcare Directive, which a lot of people use, particularly for end-of-life care. A PAD is just that, for inpatient mental health care. And you can really put whatever you want in it, but you can see on the slide here, there's an image that sort of gives you the broad sorts of things that typically go into these. There are preferred facilities, preferred medications, what you want to do when you're in crisis, like what helps you and what hurts you. Who should be contacted? Please tell my mother that I've been hospitalized, that sort of thing. There is no universal template for pads in California. There's no place you can go where they tell you this is what a pad should look like. So there's no set document from us to work from to talk about this. But MHAS has a template, and our template has three main sections. And these are the kinds of things you typically see in a pad. There's the appointment of an agent, which is where you say, I appoint so-and-so as my healthcare agent to make decisions for me when I am incapacitated. I have done pads where somebody says, you know what, I really, really trust my sister. She always takes good care of me. She always makes good decisions. I don't want any of the rest of this. I trust her. I'm just going to appoint her as my agent, and that's the whole pad. You can also limit the agent's authority. You can say, my sister can make every decision for me, except she can't consent to this medication, except she can't consent to use of restraint. You can limit the agent's authority as much as you want. The second section is these main treatment preferences. So I consent to these medications. I refuse these. I consent to these in a crisis. I consent to these if you can limit the side effects, and here are the side effects I'm worried about. Take me to these hospitals, don't take me to these hospitals, notify these people that I've been hospitalized. Our template has a section that says, if I've been hospitalized and haven't had a chance to pack a bag, I would like this person to pack a bag and bring it to me with the following things. And it often has comfort items like shoes or blankets or things like that. And then crisis response info. So let's say you experience one of these law enforcement responses. Ideally, if you could get the pad to them in that moment, they could see, I have a history of trauma, and being yelled at makes me lash out. Please talk to me in a calm tone of voice. Here are my preferences for getting to the hospital if I need to go. Information for crisis response is part of our template as well. Here are some examples of PAD instructions that I've seen. Again, there's that I appoint my family member as my agent, and sometimes they'll just leave it there. Please take me to UCLA Harbor, this particular hospital in LA. I like the doctors there, and they help me. I would like for my sister to bring a bag with some comfort items. Please do not give me this particular medication. It makes me sick and it doesn't help. And the Haldol example is a classic one. I mean, anybody who's done some pad work, I think, will have experienced this at some point. People really don't like Haldol. So a lot of times people are limiting Haldol in some way in these pads. And then you can say, okay, I'm okay with certain medications if it's an emergency, if I'm in crisis. I consent to Haldol if I am in crisis. I have a history of trauma, and being yelled at makes me lash out. So hospital staff, please, when I get angry, give me 10 to 15 minutes to cool off alone, or speak to me in a calm tone of voice about my cat or my favorite book or something like that. It's a shortcut to providing hospital staff the the information they need to provide you the best care possible, because they're doing their best in a very difficult situation. They're trying to get you stabilized and back into the community. A lot of times when somebody comes in, they can't really participate in their treatment because they're in acute crisis. This way, you come in with a pad that says, here's what helps and here's what doesn't. And it gives you a voice in your own treatment when you often don't have that in the hospital. And it gives the hospital staff a way to know what's going to help you and what's not. On the future of pads, obviously we at MHAS, and I think a lot of us on this call, think pads are very promising. They are a really, really powerful way to protect patients' autonomy, to come down on the side of individual civil rights in these situations. There is a growing body of research that shows that pads cut time in hospitals. People who have a pad spend less time in a psychiatric hospital. Having a pad reduces the number of coercive interventions you experience. A coercive intervention is anything that like keeps you in the hospital longer or is like a harsh tactic. So this includes forcible medication, restraint, seclusion, the extension of a hold into a longer hold. Research shows that having a pad reduces the number of those you experience. And then also, patients who have a pad tend to have a lot of peace of mind as a result. They feel like I have rights. I know what my rights are. Here's a way for me to enforce them. A lot of times just having this pad in their back pocket removes some of the fear and stigma of inpatient mental health care and can encourage people to get care when they need it. I will say that right now in California, the awareness of pads and the infrastructure to support them aren't really there. A majority of states, I think by last count it's 27, so slightly more than half, have a specific state law that talks about pads, that says, here's what can go in a pad, here's what can't, here's when a hospital has to follow a pad, here's when they don't, here's what to do if it's not followed, here's a template, everybody should use this template. Most states have a law like this, and California doesn't. So there's a lot of unknowns. There's not some standard template that we can all work from. So there's a bunch of different versions floating out there. A lot of states have a specific pad database where you can upload your pad and hospitals or law enforcement can easily access it. We have a pilot program that's working on that, but to my knowledge, it's not done yet. At least in my time at MHAS, it hasn't been available. And then there's this lack of awareness, in part because we don't have the state regulation and infrastructure. I think a lot of consumers don't know about this. And when they find out about it, they love the idea, but they want help with it. So we need to find ways to connect them to help with these pads. And then a lot of providers, again, I think awareness is increasing greatly, but a lot of hospital staff, doctors, therapists still don't know about this. So we have to do a lot of work to raise awareness of these. The more awareness there is, the more people will have a pad. The more people have a pad, the more we get used to just integrating it into our mental health system, the easier it will be to get it where it needs to go, and the easier it will be to get doctors to follow it. But we kind of have to start by raising awareness of these documents. So spread news of pads far and wide to anybody who might be interested. I'm going to pause after this slide for some questions. I imagine people might have questions on pads. I want to give you, from an attorney's perspective, if you are doing pad work or you are interested in doing pad work, some best practices from what I've learned doing this work. The first one I think is obvious, and I think it's something everybody on this call is going to be very good at. You got to build rapport with people, right? You're asking people to give you very, very intimate information, experiences in the hospital in the past, what medication works and doesn't, what side effects people are concerned about, who they want to know that they're in the hospital and who they don't. This is really sensitive stuff, and it's not something that I, as a lawyer, can just plop down across from you and say, okay, tell me about all this stuff. You've got to build rapport. You've got to earn people's trust. I mean, this is something that people are really trusting you with, and you've got to take your time for that. On the nitty-gritty of the pad, I always recommend that people keep instructions specific and realistic. On the specific part, so a lot of people will say in their pad, treat me with respect. Obviously, that's great, and that's what pads are trying to do. It's trying to make sure you can be treated with respect, but that means something different to everybody. Respect to me might look different than respect to you. So we want to make sure that instructions in pads are clear. It's actually clear what the person wants. So don't leave it at vague things like treat me with respect. Drill down. Be specific. What does that look like to you? What does disrespect look like to you? Get concrete, get specific. And two, it's got to be realistic. If it's not realistic, if it's I refuse all mental health treatment, or I demand a steak dinner every night, the hospital is under no obligation to follow that, and they're not going to, and it's going to hurt the credibility of the entire document, which makes it less likely that the whole thing will be followed. So you want to make sure your requests are actually realistic. You want to make it easy to read. Hospital staff are very busy. They've got a lot to do. They don't have time to comb through a 20-page document with a lot of, extraneous information scribbled in the margins. Make sure this is streamlined, clear, easy to read, so a hospital staff under pressure can just go boom, 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 and know what they need to do. The law says that a pad to be valid has to be either notarized or signed by two witnesses. Don't have to do both, just one. Notarized or signed by two witnesses. Legally, it is not a valid pad until you do that. So don't just stop at, okay, you've got your pad, it's done, go out. Make sure there's some plan to get it notarized and or witnessed. And then because we lack a lot of the infrastructure, because it's hard to get this into a database, because it can be very hard to give it to crisis response in the moment. Think about how to get this document where it needs to go. So think about maybe when you're not in crisis, when you're in a moment of good health and stability, take it to the hospitals where you often go to. That way, A, the staff gets to meet you when you are yourself, when you're not struggling. You get to build more of a rapport with them. They see you as more of a well-rounded, complete person. And they get your pad on file. So when you come back the next time, they've got that document. Make sure if you appointed an agent, a power of attorney, make sure they have a copy. Make sure anybody who you've asked to be notified of your hospitalization has a copy. You could think about, we sometimes give out cards to people that says, I have a psychiatric advance directive. Please contact this person at this number to get a copy. Think about ways to make sure this is accessible in the moment, because a pad sitting on your desk at home is useless when you're hospitalized. It's got to actually be able to get to where it needs to go. And that takes work. It's not easy, particularly in California, but really think about that. We need to make these things accessible. So that was a lot of pad information. I will pause there and take a few questions if anybody has any.
We have quite a few questions in the chat, along with people that are just sharing resources and experiences. But the first question is, what if your loved one has anosognosia and does not think that they need a pad?
That's a tough one. Um, it's really tough. So I would say the way the law is written, the person who is drafting the pad has to agree to it. You can't force somebody into a pad. On the next slide, we're going to talk about the relationship between pads and conservatorships. Potentially, if you are somebody's conservator, you could draft a pad for them because you have the decision-making authority over their care. At that point, you probably could force them to accept certain things. But if you're not their conservator and they just don't see the need for this, you can't really force it on them. The best advice I have is to have a conversation with them, to have a conversation with their treatment team to the extent they're comfortable including you in that, and just talk to them about why you think this is important. But yeah, it's tough. I mean, generally speaking, the person drafting a pad is going to have to agree to it.
The next question is, does pediatric pads work for youth under 18 years old?
Yeah, they're not really necessary because the youth under 18, their caregiver is already going to have the decision-making authority legally. So whatever the caregiver says goes. If that's what you're concerned about, you don't need a pad. However, A pad could be a really good way to include the youth in their own care. You could sit down with them and say, when you're in the hospital or when you're not feeling well, when you need help, I want to talk to you about what you feel helps you and what doesn't. And you can have that conversation together and you can bring the youth into their treatment. You can give them a sense of agency over it and you can help them draft a pad. And that pad can go to the hospital with them and it can tell the hospital staff what they need to know. Again, legally, I would say it's not necessary because as their caregiver, the caregiver is going to have the legal decision-making authority, but the pad can be a really wonderful way to include youth in their own treatment plan and get them thinking critically about what has helped me in the past and what hasn't.
I think you sort of answered this one, these next couple already, but there's a question asking, is the practical recommendation that one's agent finds out that you're going to a hospital and they bring it? And then somebody else asked about creating small cards to carry in your wallet or purse. So I don't know if you have anything more than what you've already shared to
Yeah,
elaborate on those two.
I would say on the logistical issue, it's just sort of think about everything. Think about getting it there before the crisis. Think about making sure your agent knows and having them get it there. Um, I would say cast a wide net. Do as much as you can to make sure this is going to get where it needs to go. I think the cards are a really good idea. We've often seen people use bracelets. The bracelet will say, "I have a pad, contact so and so." I think it's a good idea to have some sort of small object that directs people to the pad.
Next question is, what about minors in foster care who have a developmental diagnosis or minors who have limited verbal ability?
Again, if they're a minor, the caregiver is going to have decision-making authority, so a pad is not strictly necessary. If they are nonverbal, it's going to be very hard to draft. If they're non-speaking, nonverbal, it's going to be very hard to draft a pad for them. Pads only work when a person can really participate in the discussion. So a pad might be tough in that situation. I would say for other developmental disabilities, intellectual disabilities, a pad can absolutely work.
And then the last question here is, what can be done when a pad is grossly neglected? What is the process of a pad infrastructure type of law to be created and followed similar to other states?
Perfect segue into the next slide. So I just wanted to hit some basic FAQs here, and we'll get to that question. So first, what's going on with pads in California right now? I think some of you might know more about this than I do. You might be in the county where this pilot program is happening. California has a pilot program where in 7 counties, they're working on building out pads. They're working on building an infrastructure, building a database, training people to draft pads, training law enforcement to access them. I think at one point they were working on this app where you could like pull up your pad on your phone and just show it to whoever needed it. This has been going on for a long time. And last I heard, they were kind of behind schedule on some things, but there is this movement in California to try to make this happen. There is also the movement to have the state legislature step in and say, okay, here are some rules for pads. To my knowledge, that effort has stalled the last couple of years, but it's always something that I think we should think about pushing for. It would really help if we had a law that says, here's when you can challenge a pad, here's when you can't, right? If we had some firm rules on this, some firm pad-friendly rules on this, I think it would be a big help. So to your point, what happens when a pad is grossly neglected? Or, what happens if someone legally challenges a pad? If they say, I don't think this person had capacity to draft a pad, the answers to these sorts of questions is we don't really know, because there's not a firm legal framework on this. I would say if someone's pad is grossly neglected, there's a couple things you could try. You could try, if you're in a publicly funded hospital, you could try the local patient's rights advocate. You could try, in LA County, we have the Department of Mental Health. You could try a Department of Mental Health grievance. In theory, you could sue. You could say that this medical provider willfully, wantonly neglected my pad. They violated my rights under California's Advanced Healthcare Directive statute. I think that's a very difficult case for a lot of reasons. This has never happened before. We never had a lawsuit like that in anywhere in this country, from what I can tell. So my advice is to communicate with the hospital staff to let them know why it's important that this pad be followed, to file any appropriate grievances that you can. And I think we need to keep working on raising the infrastructure for the infrastructure and the awareness for pads so that this doesn't happen. And again, to the next point, I'm often asked what happens if someone legally challenges a pad. I don't know. To my knowledge, it's never happened. I think it would be a tough case because the law assumes capacity. It assumes that somebody, when they draft a pad, has the capacity to do so. So you would have to, A, have standing. You'd have to show that you were hurt in some way by this person having a pad. That's tough. And B, you'd have to come in with evidence that this person didn't have capacity. I think it's very unlikely to happen. I don't have a super satisfying answer to that last question because it's tough, and we need to continue advocating for the state legislature and state executive agencies to make sure we create this infrastructure that we need. And finally, how do PADS and conservatorships interact? Again, the way I read the law is that if you are a conservator, you already have the decision-making authority. So a PAD would not be necessary, but you could sit down with the conservatee and draft a PAD. The way I read the law, if a PAD says one thing and a conservatorship says, the conservator says another, I think the conservator would win out. But again, we don't know that. It's never been challenged. It's never been brought to court. We don't exactly know what would happen. So one of my broader points is that there are a lot of unknowns about PADS, and it sure would be great if the state legislature would do something about that. Okay, I think that's enough on PADS, but I'm happy to take further questions on that today or at a later date. Let's get back to the overall theme of kind of mental health law, right? Throughout our history, we have reached these inflection points. We've reached these points of crisis where we've said the current system isn't working. We've got to blow it all up and do something else. Here today in California in 2026, we are facing, I think, a mental health crisis. There are a lot of public displays of mental health disabilities. A lot of people aren't getting the care they need. They either can't access it at all, or when they do access it, it's not the care they need. Many people conflate the mental health crisis and the housing crisis. My argument is that these are two different things with some overlap, certainly. I've worked with clients who, because of a mental health disability, it can be harder to get them housed. There are ways in which their symptoms affect the stability of their housing. That's true. There is some overlap. But I think a lot of policymakers these days say these are one and the same. There is a Republican candidate for governor who a couple of weeks ago said we don't have a housing problem, we have a psychosis problem, or something to that effect. A lot of people conflate these two things, and my argument is they're actually different. There is the mental health crisis. There is also the housing crisis, and the housing crisis is driven by economic factors. The housing crisis has happened because wages are too low and rents are too high. What happens is people get behind on rent for whatever reason. They can't afford it. It's really expensive to live in California or anywhere these days. They lose their housing, and then the trauma of that contributes to a mental health disability, which can in turn affect their housing, sure. But these are sort of different things. And I think a lot of policymakers these days want to conflate the two when actually they're more distinct than a lot of people realize. But because of this merger of these two things, and because we definitely have these two crises, there is a housing crisis, there is a mental health crisis. A lot of people on all sides of the issue are unhappy with the current system. They say deinstitutionalization didn't go far enough, or they say it went too far and people are dying with their rights on, and the state needs to be able to step in and help people. A lot of people on all sides of the issue are really unhappy with what we have currently. And my argument is that we have repeated our history. Psychology teaches that human beings repeat. We repeat on a micro level in our own personal lives, but we also repeat on a societal level. And we are repeating over and over again this process of hitting these inflection points in mental health law, deciding the old system doesn't work, and trying something different. I think we've come to that point again. So where do we go from here? Given that we're at this inflection point, given that I think a big change in mental health law is coming and already happening to some degree, there are two paths forward. Path one is to say deinstitutionalization was the right idea. We had the right idea to value individual autonomy over public safety, to include a lot of civil rights protections for people in the mental health system, to focus on community-based treatment and not locked facilities and inpatient solutions. Path one would be to recommit to those principles and fund community-based treatment. Take a holistic view of mental health. Realize that it's being driven by a lot of non-medical factors. Realize that people need stable housing. They need stable income. They need to be free from being harassed by a creditor for that money they owe. And we would also re-examine mental health treatment. We would realize that medication and 16 sessions of talk therapy are not going to fix everything, that we need a more holistic, patient-centered view of it. This would require a real shift in resources. We'd have to really think critically about our budget priorities. We'd have to think really critically about what works and what doesn't, and what we want to fund and what we don't. It would be a significant undertaking. But that's path one, is to say we need to protect people's autonomy. We need to recommit to the principles of deinstitutionalization. And if we actually do it right, it can work. Path two is to say deinstitutionalization did not work. There's too much individual autonomy and there's not enough focus on public safety. People need help that they're not getting. They need intensive help. So we need to double down on coercive treatment. We need to make it easier to conserve people, to hold them in the hospital. We need to get them off of the street and into an inpatient bed. We need to just hit the problem hard. One way this might look is that you might loosen the criteria for involuntary commitment or conservatorships or other state intervention. You might say that homelessness and mental illness are the same thing, or at the very least, these crises are inextricably linked. And so you might conduct a lot of sweeps of people living on the street, and you might say, let's just round them all up and put them in a hospital or a jail. Let's just get them off the street so we don't have to see it. And we might build more locked facilities, the theory being that people need intensive inpatient care, not community-based stuff. So I am far from a pessimist. I think this is an ongoing debate. I think the decisions have not been made here, but I think we have to acknowledge that path two has some momentum. Path two being the path of undoing the move to individual autonomy, undoing deinstitutionalization. For one thing, there was a Supreme Court decision from a couple of years ago, Grants Pass. Grants Pass is a city in Oregon that wanted to remove people, unhoused, unsheltered people from the street if they refused mental health treatment. Their argument was that these are people who have mental illness invariably. They don't want to accept treatment or shelter. And so if they don't accept that, we ought to be able to say that that's illegal, that that's criminal, and we can either jail them and force them into treatment, or we can ship them out of town. The Supreme Court bought that argument. So I'm sure we've all seen in our communities at least some increase in sweeps of folks living unsheltered on the street. Grants Pass permits this. There's also executive order at the federal level, 14321. This is a picture of Donald Trump signing this executive order. It directs states and cities to prioritize involuntary commitment and encampment sweeps. Think less about outpatient community-based care. Think more about how you can get people into locked facilities. And then in California, we've seen many examples. Again, I have a knowledgeable crowd here. I don't think we need to go into the details of each of these, but Senate Bill 43 from a couple of years ago loosens the criteria for gravely disabled, so it makes people more eligible to be involuntarily hospitalized. It makes more people eligible to be conserved. It also loops in substance use. All of these laws we're talking about used to just be for a mental health condition. Now we've changed to behavioral health, which includes substance use. So now if you are gravely disabled due to a substance use disorder, you're up for involuntary holds and conservatorships. Of course, there is Care Court, which we'll talk about in a little bit more detail. And then there is Prop 1, the transition to the Behavioral Health Services Act, which we're all living through at the moment. I'll say a few brief things about that as well. So first, Care Court. Again, I think at this point we all know what this is, but it's a court system designed to connect people in crisis to mental health treatment. The theory is that these folks need treatment but can't access it, so we're going to, and sometimes they don't want it, they're not voluntarily accepting it, so we're going to bring them in using the coercive power of the court, and we're going to force them to get this treatment. Now, we're also going to connect them to people who are supposed to help them. They can appoint a supporter, they'll have an attorney, but we're going to bring them in using the power of the law, the power of the court, and force them into some sort of treatment plan. I cannot speak to what's happening in care court across the state because I think it happens very differently in different counties. But I'll give you a snapshot of what I'm seeing of it in LA County, which I do think is somewhat indicative of what's going on across the state. So how it works in LA County, someone files a petition. Usually it's a family member of the respondent, of the person who's the subject of the care court proceedings. When the petition is filed, the court investigates. The court investigates to see whether this person meets the criteria for the program, meaning they have a schizophrenia spectrum diagnosis, meaning they are not currently in voluntary treatment. If the court finds that that's present, if they don't find it's present, then they'll just dismiss the case. If they do, it goes forward. And then the next step is to serve the respondent, to give them the court paperwork and tell them that they are the subject of this legal proceeding and they need to come to court. In LA County, this is usually where it falls apart because often the respondents of care court petitions are unsheltered. They're jumping from place to place. They're in an encampment where court staff can't find them, doesn't know how to find them. So usually they don't get served, and that's where it all kind of falls apart. If they get served, then they have their upcoming court date. And we found that when people don't show up, which they often don't, the judges just kind of dismiss. They say, okay, this is a voluntary program. We're not going to like issue a bench warrant to go arrest this person and bring them in. If they don't want to come, we're going to call it voluntary and we're just going to dismiss the case. So what do we make of care court? Well, first, I will say I completely understand the argument for care court. Again, the state legislator who sponsored this bill says that people are dying with their rights on, like we've gone too far to the side of individual autonomy. The state needs to be able to step in and help people who sometimes don't even know that they need help. And we need to use some force to get people into care and to get people the help they need. I understand that argument completely. And I hear the pain in family members' voices when they talk about this, because we have a system where it's really hard to get your loved ones help. And I understand the appeal of a system like care court that gives you a way to make them come in. I totally get that. I think a lot of people like me, advocates for people with mental health disabilities, would tell you that care court is not the way to do it because it's coercive treatment, right? And coercive treatment generally doesn't work. There's a growing body of research on that. Mental health care works best when you are an active participant in your own treatment, when it's not being forced on you. Also, again, to my earlier point, a lot of what goes into people's mental health is things like income, housing stability, these sort of economic factors. If you come into care court and care court orders you to undergo treatment, that can be a start, but it's not going to fix the underlying economic issues that are driving your anxiety, your fear, your trouble making ends meet. And I think it's a short-sighted view of things because it's addressing a very tiny part of the overall problem. And care court, at least in LA County, doesn't have a lot of connections to other services. So you're expected to just sort of get yourself to treatment, whether you have a stable job, stable transportation, stable housing. There's not a lot of empathy for what might be going on in the person's life. I will say that I think the tide of care court is shifting. It passed a few years ago. It was implemented. It remains very popular with the governor and his administration, but I'm hearing a lot of unhappiness about it. For one thing, I just heard from our friends at Access California that a recent analysis found that the cost of a care court petition is about 700 grand. It's almost $1 million. That's extremely expensive. And I think a lot of state legislators are starting to see that number and think, I don't know about this. Are we really seeing the kind of return on investment that we would want to see for a number that high? Again, in LA County, the consumers that I speak to who go through this process and the family members seem unhappy with it. Their issues are slightly different, but they both agree that this care act, this care court isn't working. I think the narrative around this has shifted. You've heard some gubernatorial candidates say that they're not really thrilled about this. They don't see the return on investment. You see a lot of unhappiness even among people who supported the CARE Act. I think it's losing support. I think it's not doing what it was supposed to do. And I don't know how much longer it's going to be around. I think the big question, and it's not a question that we can answer yet, we'll have to see how it plays out. The big question for me for the CARE Act is what happens under the new state administration? When a new governor is elected this year and takes office next year, what will they do with CARE Corps? What will they do with mental health policy generally? Will they go down path one or path two? But specifically, what are they going to do with the CARE Act? I don't know, and it'll be really interesting to see. Prop 1, again, I have a very knowledgeable crowd here. I'm not going to belabor the point. You all know, I think, what Prop 1 is. I think the context is useful here. We used to have the Mental Health Services Act. The Mental Health Services Act was, it was in the spirit of deinstitutionalization, right? It funded a lot of really creative, consumer-forward innovation, like the use of peer services and peer clubhouses and things like that. There were some pad projects under Prop 63, the Mental Health Services Act. There was a lot of really creative stuff, and there was a lot of local control. The state could go its own way because we weren't really concerned about, you know, tapping into Medicaid funding to the extent possible. There was a lot of ability for cities and local governments to innovate. It was a very consumer-friendly, creative system. It ultimately failed because not enough data on outcomes were tracked and too little of the money was spent. Support eroded over time, especially with the current gubernatorial administration. And so we moved on to Prop 1, which passed a couple of years ago. I think what's important to understand about Prop 1 in the context of mental health law and in the context of the inflection point in which we find ourselves is that it's going down that second path, right? It's a step away from deinstitutionalization. It's a step away from these community-based innovations. It's a step towards more hospitals, more state control over local decisions. It's a step away from the deinstitutionalization of the past. And a lot of these, like, really cool, in my view, really cool programs under the Mental Health Services Act, it's exactly what the Behavioral Health Services Act cuts. So my argument on Prop 1 is that it is a sign of where things are going. It is a sign of a return to more inpatient treatment, more coercive models of treatment. And I think a lot of us have experienced cuts as a result of this. I think we all see kind of what Prop 1 is trying to do. Again, I think you all know this, but I just want to highlight some of these big changes. You've got to build Medi-Cal to the extent possible, which limits what you can do. It raises funds to build more hospitals, not community-based treatment centers, but hospitals. There's more state control. The state has more say over more of the money. And it has this weird requirement where a lot of mental health providers, like the Department of Mental Health in LA County, now have to spend funds on housing, not treatment, which I would argue is an inefficient use of resources, given that the Department of Mental Health has never been involved in housing policy. It's asking a lot from them to take 30% of their budget that was being used for mental health services and use it on housing, which they don't even know how to do. You've all seen the headlines. You all probably lived these headlines. We're all experiencing these cuts. But here's just a brief synopsis of some of the headlines you're seeing in the Prop 1 era. A lot of programs are being cut. A lot of consumers are losing the lifelines that they have relied on and the resources that they have relied on. And we're navigating a very different landscape than we were just a couple of years ago. The Behavioral Health Services Act, Prop 1, changes things pretty dramatically. And so that leaves us where we are today, which is in the midst of this inflection point, in the midst of a great argument about where we go from here. To what extent should we privilege individual autonomy? To what extent should we privilege public safety? Do we need more inpatient, coercive, forced treatment? Do we need more community-based, patient-forward treatment? Do we stick with the current system, which has some sort of weird mix of the two? This is an ongoing, raging debate across the country, but especially in California. And it's a debate that we're going to continue having. I want to conclude by saying I think I would be remiss if I didn't mention that it's a very scary time for all of us. There are a lot of really dramatic changes, particularly at the federal level. As a lawyer, I would argue that civil rights and the rule of law generally in this country are under attack in ways that we haven't seen in a long time. And anytime you live through a period like this, anytime you live through a period where everybody's rights are under attack, it's going to hurt vulnerable people especially hard. And mental health consumers, people with mental health disabilities, are especially vulnerable to this attack, to things like grants pass, to things like the executive order. And as the threats become more serious to us all, it's going to hurt mental health consumers in particular. The threats are becoming very serious to them, to us, to our community. Um, I would leave you with a message of hope that while things are potentially trending in a way that a lot of us aren't happy with, nothing has been decided. This is an ongoing debate. There are a lot of people on both sides. We're in the middle of an election in this state. That's going to have a big impact on which way we go. The future of mental health policy is very much still up for grabs. And whatever you think that future should be, whatever you think mental health policy should look like, now is the time to fight for it, because it's all up for grabs right now. We've hit this inflection point. We've reached a point of crisis. We are on the verge of kind of blowing up the whole system and starting something new again. Now is your chance to fight for what you want, because it's all on the table right now. I would argue, and I think a lot of us would agree, that we have to keep pushing for community-based, consumer-centered treatment. Every time we've hit this inflection point in American history, we've gone forward in some way. We've responded with empathy. We've come up with a more compassionate, treatment-based system. We have moved forward slowly but surely. I think a lot of people want us to move backwards. I would argue that undoing our deinstitutionalization would be moving backwards. And I think we moved forward for a reason. So I hope you all will join me in this fight going forward, especially over the next year or two, because mental health policy is going to change a lot. It could change in really any way. We get to fight for what we want right now. And I hope you all will join me in that. And I hope you all will take hope that a better future and a system that works for more of us more efficiently and more humanely is very possible. We just got to fight for it. And now is the time to do that. So that is my presentation. I can pause here again for more questions if anybody has questions.
Thank you, Eric. We have a question in the chat here that says, do you have any recommendations on dealing with the shortcomings of MHSA to deal with the bad in quotes, direction of BHSA?
Okay, if I understand the question correctly, it's how do we deal with the potentially bad direction of BHSA? You're concerned that we might be going in the wrong direction. I think the best way to do that is to make your voice heard at these local planning commissions. Find the people in your area who are implementing BHSA, who are deciding, what the plan's going to look like, what the policy's going to be specifically, and show up at these boards, show up at these commission meetings, show up with your coalitions, with consumers, and make the case for why it should be a different way. They need to hear from us, and they need to hear from us frequently and in great numbers. Get involved in these policy-making decisions. David, you have your hand raised.
Yeah, thank you. Thank you very much. Sorry I had to take off. My mom's in the hospital right now, but I come from this you said everything. I can say ditto to everything that I just heard. There's no doubt about that. The one thing I just wanted to kind of reiterate, you're talking about local area, but I think the question might also pertain to statewide and how we can get involved in this statewide hunt by going to the Behavioral Planning Commission. There are a lot of state folks involved right now, places like the Steinberg Institute, where they're really doing a lot of forward-thinking stuff. And I know that's getting a little controversial. I don't want to get into that because there may be some people who are not as hip on the Steinberg Institute as I am. But and our legislators, call your local legislators and make sure that they know that we're very frustrated and very concerned over the direction that we're going. I just wanted to add that. I thought it was really important. Thanks.
Yeah, excellent point. I agree. Got to make your voice heard at all levels, local, state, you name it. I agree completely.
Erik, do you have any resources or places that have done research on the value of uh, community-based, consumer-centered assistance versus the more coercive institutionalizing of mental health consumers? So anyway, um, and it does feel a little overwhelming dealing with the state and when the governor has, um, his voice and it's, um, but but I know a lot of us on this call are committed, and Cal Voices and Access California have been really good at helping us build a certain amount of momentum, and I hope it continues to build where we are communicating in a way that can shift some of the thinking of our politicians, especially. Um, but anyway, any thoughts or any further thoughts or specific information that we can use to kind of bolster where we're coming from?
Yeah, I know there is some research out there. It's an under-researched topic, so there's not as much as there should be. There is some out there. What I would say is that if we're talking about policy advocacy and talking to state legislators, sometimes the anecdotal evidence can be equally compelling. I think if consumers come and explain, I've had it coercive and I've had it more voluntary, and the voluntary stuff works better and it makes me more likely to seek treatment in the future, I actually think that can be equally, if not more compelling. So there is some research out there, and we should use that, and we should try to generate more of it, ideally. Um, but we should also use the more anecdotal stuff. I think individual experiences can be really, really powerful.
Um, we have a question in the chat from someone who is a professional writer and wants to know what she can do to help the fight, letter writing campaign, and just kind of where to start with that.
That's really interesting. I think writing is, in some ways, one of the best things you can do with this issue. I mean, we need to get our ideas out there, right? This is a battle of ideas. There are two sets of ideas that are competing right now. And the more we get our ideas out there and in the public consciousness, the better shot we've got. So I think you should start with writing your feelings about the situation. I mean, I think we all have a lot of strong feelings about what's going on in mental health policy. Start with writing what you're scared about, what you're angry about, what you're anxious about. Just get the feelings down. And I think from there it'll guide your advocacy. As a professional writer, obviously you're a very strong writer. So I think op-eds are really good. I think writing to your legislators is really good. I think anytime you can get your writing in front of the public or a decision maker or both, that's a really, really useful tool for our movement. So I would just say write about it, write a lot about it, and communicate that writing to decision makers and to the public. We need to kind of capture the public's imagination here. We need to win this battle of ideas.
We have a question about the 7 counties that are piloting pads, and how did they pick those 7 counties? And do you foresee more counties joining into that?
Yeah, I don't know how they picked it. I started this work in about 2021, and I believe they had picked those counties in like 2020 or 2021 or maybe 2019. It's a little bit before my time. I don't know how they picked those counties. I don't know if they're going to expand that anytime soon. The theory of this pilot project was that it was a pilot project, right? We were going to try it for these 7 counties. And if it worked there, we were going to take the lessons we learned and we were going to spread it to the whole state. So yes, in theory, other counties should join in. And I see a message in the chat that these counties chose to opt in and that Alameda actually recently opted in to become the 8th. So there you go. Another one is joining. Yeah, in theory, this pilot project is supposed to set the table for the whole state to do this. It just seems to be happening slowly.
There's another question about Prop 1 and whether that could possibly be reversed.
That would be a big undertaking. I mean, it'd be tough. I also don't know what exactly the status of this was. It was a statewide initiative, right? It was passed by ballot initiative. So my gut feeling is that it would take a ballot initiative to undo it. I don't know that. I don't know that. That might not be true, but my gut feeling is that it would. So you'd have to get it back on the ballot. And I don't know that much about the legislative process. I don't even know how you get things on a ballot in California. But you'd have to get it on the ballot and you'd have to win the election, which I will say Prop 1 barely passed, right? Like it took us 3 weeks to realize that the Yes campaign had won. So it might be possible to win the election if you can get it to that point. But I think Prop 1 has a lot of momentum at the moment. I think we're all neck deep in implementing it. I think it's going to take some time and it's going to take some visible failures on the part of Prop 1 for us to get there. We're going to have to generate evidence that this clearly isn't working.
That's it for the questions that I'm seeing. But thank you so much, Eric. This was so insightful, and we're just really grateful for the information and your experience and being willing to share all of that with us today.
It was
I
my
think a lot of people
pleasure.
on the call are feeling the same way. So thank you.
Of course. It was my pleasure. I really appreciate you all being here. I am going to drop in the chat here, I'm going to drop our website and I'm going to drop my email. And please feel free to reach out with any questions.
Oh, I just put one more comment in the chat.
Mhm.
Could you read it, please?
Oh, give me just a second to find it. Yeah.
Okay, thank you.
Okay. Where'd my chat go?
Or it's more like a concern.
I'm having trouble finding it. Could you just share it with me here?
Yeah, I'm worried about aging caregivers, parents maybe who are taking care of loved ones at home that maybe don't have insight into their challenges and can be violent and difficult to live with. Um, it's there are a lot of people living at home with older parents, and also the people who are living at home need a lot of support for like instrumental activities of daily living. And if when the parents pass away, um, where are they going to go? Where are they going to live? Who's going to take care of them? Who's going to do all these things that the parents are doing for them, like managing their medication, managing their benefits, helping them with anything, food?
Yeah. Yeah. You're right to be concerned. It's a very, very tricky issue. Um, the best advice I can give you is planning, right? Plan with things like advanced directives, plan with things like trusts and wills and things like that. The best you can do is plan the best you can. It is in some ways, I think one of the bigger issues our society is going to face in the coming years, because you're right, there's a lot of people in this situation and we don't have a clear plan for what to do. I share your concern. The best advice I can give now is do whatever planning you can.
Okay. Yeah, thank you.
Thank you, Eric.
Thank you all. I appreciate it.
Very, very helpful. Appreciate it.
It's my pleasure.
Yeah, thank you all for being here. As I mentioned before, this will be on YouTube. By the end of next week, we'll have it posted.
All right. Thanks, y'all. Have a great day. Take care.